Hello everyone. Here are 5 things to know about Bill 184 and residential tenancies. The Ontario government just announced that Bill 184 affecting residential tenancies is now law, and that the emergency stay of eviction proceedings will expire for the most part on July 31st, 2020. Here are 5 things you need to know. Number 1, compensation to tenants if a unit sold to a buyer moving in on closing. Previously, a landlord only paid 1 month's rent as compensation to a tenant if they wanted to move back into the unit at the end of a lease. Now, this 1 month's rent must also be paid to a tenant as compensation if a buyer will be moving in on the closing of a real estate deal. If the buyer is not moving in, then they must still accept the tenant. In addition, if an eviction is based on a home that is going to be demolished, 1 month's rent must also be paid as well as compensation to the tenant. Number 2, landlords must show good faith when evicting tenants when there is no fault of the tenants. If the landlord does want to evict because they or their family are moving back into the unit, besides the compensation of 1 month's rent, the landlord will have to provide a sworn affidavit that they have not tried to use this reason at any time over the prior 2 years to prevent a landlord from using this reason to perhaps trick a tenant into vacating. In addition, if the landlord does evict in bad faith and does not actually move back in, they can be liable to pay the tenant up to 12 months' rent as compensation. Number 3, penalties are increasing. As further protection for tenants and to make sure landlords do not act in bad faith, the penalties for violating the Act are increasing to $50,000 for an individual and $250,000 for a corporation. This is also intended to, among other things, prevent the use of a renoviction, for example, to evict multiple tenants from a building. Number 4, will there be automatic evictions if a tenant misses a payment after a payment plan is made with the landlord? This is causing all kinds of negative headlines in the press for the wrong reasons. The new bill is trying to encourage landlords and tenants to work together to settle their differences, especially when rent is owing, to agree to a reasonable repayment plan. This is good for everyone and avoids the cost, delays, and ill will of litigating everything at the landlord and tenant board, where there are already severe backlogs of cases. What the Act is saying is that if the tenant fails to live up to the agreement, the landlord can apply to evict them. However, the tenant would still have the right to a full hearing if they want to dispute this eviction. Number 5, how will the case backlog affect current eviction requests? Just because evictions will be lawful again, it still could take months to schedule a hearing, obtain an eviction order, and enforce it with the sheriff. It makes more sense to always try and settle any eviction amicably, even if it means offering extra compensation to the tenant and trying to assist the tenant in finding another place to live. Better than spending a lot of money on lawyers or paralegals to fight instead. If you have any questions on landlord and tenant issues and how to close your real estate agreement when there are issues with tenants, please do not hesitate to contact me at mark@RealEstateLawyers.ca or toll free at 1-888-876-5529. Thank you.